All persons having business before the Honorable Associate Judges now presiding over the District of Columbia Court of Appeals. Draw near and give your attention. God save the United States in this honorable court. This honorable court is now in session. Please come to order.
Thank you. Good morning. We have two cases on this calendar this morning. The first is Ortiz-Melgar versus United States. Counsel, you may proceed.
Thank you, Honor. Good morning. May it please the court. My name is Montrell Scape and I represent Mr. Ortiz-Melgar in this appeal. Mr. Ortiz-Melgar was arrested, charged, and convicted of voyeurism based on photographs seized from his phone. Mr. Ortiz-Melgar challenges the evidence that was obtained from an illegal search of his phone, as well as an unlawful seizure of his person. Beginning first with the seizure, Mr. Ortiz-Melgar contends that Officer Bibb lacked probable cause to seize him and his phone at the time that he did. According to Officer Bibb's testimony, he first was alerted to a situation between Mr. Ortiz-Melgar and the victim. He approached both parties, observed, saw that they were standing fairly close together and looking at Mr. Ortiz's phone. The officer immediately looked over, saw what he thought was an upskirt photograph matching what the victim was wearing, and took possession of Mr. Ortiz-Melgar's phone. By the officer's own admission later in his testimony, he did not know what was going on at the time. He did not know the relationship between the parties. He had no context. He was operating solely off of what he saw on the phone. At that time, not only did he seize the phone, he also physically seized Mr. Ortiz-Melgar. He placed his hand on Mr. Ortiz-Melgar's arm, grabbed him, and led him away to another part of the Metro Rail station. At that point in time, Your Honor, we would argue that Mr. Ortiz was unlawfully seized. There was no probable cause for the seizure, and that was, in fact, under the law, a physical seizure. In addition to physically removing him and separating him from the victim, Officer Bibb made it clear that Mr. Ortiz-Melgar was not free to go. He had him sit on the floor, and when Mr. Ortiz-Melgar attempted to stand again, Officer Bibb did something with his feet. He would not admit that he actually forced his feet apart, but he did cause his feet to come apart so that Mr. Ortiz-Melgar would be forced to sit on the floor of the station. And at that time, Officer Bibb got into Mr. Ortiz-Melgar's face, pointing his fingers. And mind you that there was a language barrier here. Mr. Ortiz-Melgar spoke only Spanish and Officer Bibb spoke only English. That was made known at trial as well. Officer Bibb proceeded to tell Mr. Ortiz-Melgar that he was not free to go. Given the totality of these circumstances, it is absolutely clear that Mr. Ortiz-Melgar, had been seized unlawfully, and that he in no way felt no reasonable person in those circumstances.
Do you think,
would feel free?
Let's assume you're correct. Ms. Gabe, are you able to hear me? You know, am I the only person who's been having some sound problems in hearing you, or have my colleagues on the bench also?
A little echoey.
Because I have found that in listening to you, your voice occasionally goes in and out, and I can't hear some words you've said. But I have gotten the gist of your argument, and I want to ask you this question. Suppose we agreed with you that there was no probable cause initially when Officer Bibb pulled Mr. Ortiz aside, took him about 20 feet away, made him sit down. But we thought there was reasonable articulable suspicion to investigate further and to justify an investigatory stop. Where do you think that would leave us?
I think, Your Honor, it would leave us pretty much in the same position. Even if it was an investigatory stop, the search of the phone, which is another main contention of Mr. Ortiz-Melgar, was still unlawful. Even if he had been under arrest and in custody, as Officer Bibb tried to state, the search of the phone would have been illegal because at that time there was no warrant to search the phone.
Well,
Oh, sorry. Go ahead.
Go ahead, Judge Becker.
I mean, then you have the problem, which I think is, to me, that one of the more interesting issues in this case. Why doesn't the independent source doctrine undermine your argument in that regard?
Because at the time, because the independent source, you would have to prove, Your Honor, that the information that was used in the application for the warrant was wholly independent of the unlawful seizure and search. And I don't believe, Mr. Ortiz-Melgar doesn't believe that was the case. You cannot separate what was told to the officer by the victim and from what Officer Bibb observed on the phone. And if there was not sufficient attenuation to purge the illegal seizure and search of the phone.
Is your argument that there's like a difference in quality between what the complainant would say and what the officer saw, or what does that boil down to?
No, it's not, Your Honor, it's not a difference in quality in terms of the information, but our position is that you cannot use what you observed during an unlawful search to serve as the basis for your probable cause to then obtain a warrant. And that is what Officer Bibb did in this case.
But can you be more detailed? And because what we know is that Officer Bibb saw something on the phone when he initially approached the complainant and your client, right?
Correct.
So he has that information separate and apart from the search that you say, or the seizure that you say is illegal. And then he also has the information that he gets from the complainant, which is separate and apart from the seizure that you say is illegal. So what information that makes it into the affidavit for the warrant can you say is attributable to him looking at the phone? Or is your argument it's the government's obligation to show that this isn't attributable? Can you walk us through what your line of thinking is?
Yes, Your Honor, and you're absolutely right. That is our position. Our position is that it is the government's responsibility to show that the information contained in the warrant was wholly independent, based solely on what the victim told the officer with regards to what transpired. And we do not believe the government can meet that burden because—
I'm sorry to interrupt, but it can't be solely based on what the complainant told, because like I said, the officer also had his own personal knowledge based on what he saw on the phone when he first approached the complainant and your client, right? So there are two bases of information that are separate and apart from what he saw on the phone subsequent to what you say was an illegal seizure.
I understand what the court is saying. What our position is that all of it intertwined, and because there was the government failed to convince the court of could not discern what came from the officer's initial viewing or what the victim allegedly told him and what came from the search, that it all had to have been suppressed because it all was based on, from what we understand, was the officer's illegal seizure of the phone and illegal search of the phone. Although Officer Bibb saw what he thought was an upskirt photo, there was no context for that. And he didn't just stop there, Your Honor. He then made Mr. Ortiz-Melgar open the phone to view the photo again and, in fact, to view other photos. And it was based on that information, our position is based on that information, that he did at that point determine that he had enough cause to then seek a search warrant. And this was prior to even speaking with the victim. He spoke with the detective at the same time he was speaking to the victim to get the information necessary to apply for the search warrant. So at that time, there was no way to discern exactly what came from the victim and what came from the officer's own observation. And in any event, we would submit that it was the officer's observations after he seized the phone and not the glimpse that he had prior to seizing the phone that served as the basis for his probable cause to get the warrant.
Well, Ms. Gabe, I'd like to go over the facts with you a little bit closely here because I don't quite follow your argument. So let me take this step by step with you and see where you think there's a problem and where there really isn't. Officer Bibb and the complainant get to the top of the escalator, and the complainant is signaling to Officer Bibb to come, and the Officer Bibb can see that she's in some sort of altercation with Mr. Ortiz. By altercation, I simply mean a verbal confrontation. Bibb comes up there, and according to his testimony, not contradicted by the video, he sees what appears to be an upskirting photograph on the cell phone in Mr. Ortiz's hand. Now, up to that point, you would agree there's been no Fourth Amendment violation, right?
At the point that he takes the
At the
phone,
point that, just bear with me, up to the point that he sees what appears to him to be an upskirting photograph, and he's explained why it appears that way. There's been no unlawful search or seizure because the phone is still in Mr. Ortiz's hand. It just happens that Ortiz is holding it in such a way that the officer can see it.
correct.
Okay. Now, seeing that photo in the context of this altercation, even though he doesn't apparently get any information at that point in time from the complainant, he draws the conclusion that he has grounds to separate these two people, to take Mr. Ortiz where he takes him, and in effect, perhaps, certainly a seizure. It's certainly a seizure, and perhaps it is a seizure based on probable cause. Perhaps it is a seizure based only on reasonable articulable suspicion. Are you with me? So, do you agree with that, or do you just? Okay. Now, the government argues there was probable cause at that point, and if the government is correct, if we agree with it, there was probable cause at that point, then the officer could seize the phone in connection with a search incident to an arrest. Even if there wasn't probable cause at that point, if we posit that there was grounds for an investigative stop, maybe the officer grabbed the phone prematurely, but within a few minutes, he gets more information from the complainant, and the complainant, once he hears from the complainant, he certainly has probable cause to make the arrest. And even if he took the phone a minute or two earlier than he should have, ideally, what difference does it make? He certainly has probable cause to take it then and seize the phone then. Now, do you agree with that?
Yes,
Is there anything wrong with that analysis so far?
So far, no, Your Honor. It's the search of the phone that occurs afterwards.
Right. So, on the one hand, then Officer Bibb apparently scrolls through the phone and sees other photographs besides the one he's already seen. Okay, and let us assume we agree with you that search. Let us assume two things, actually. Let us assume we agree with you that search was not justified, because Riley says you normally need a warrant to search a cell phone seized incident to an arrest. Okay, and let's also assume that we don't agree that Mr. Ortiz consented to this. The judge relied in part, as one alternative ground, was consent. Let's assume we don't agree that there was consent. Okay. But then what we know is that the detective who applied for the warrant said that when he applied for the warrant, he knew only about the sighting of the first photo, the one single upskirting photo. And he did not know, he was not told, and did not inform the magistrate that other photos had been found on the phone. The magistrate issues the warrant, in other words, and the warrant is untainted, the government argues, by the improper scrolling through of the phone. Why shouldn't we therefore hold that there was an independent source for the subsequent examination of the telephone.
The independent source,
In fact, you've already agreed with me that there's no real problem with the seizure of the phone in the
Correct.
end. And so the only question is, okay, how did they get the photographs used at trial from that phone? And the answer seems to be from an untainted warrant. What's wrong with that analysis?
Your Honor, and forgive me, my time is out, but I will answer the question. The problem is, Your Honor, there wasn't an independent source. According to Officer Bibb's testimony in the sequence of events, he had not yet spoken with the victim. He had no information. He had no context. So Officer Keenan, Detective Keenan, testified that he applied for the warrant based on what Officer Bibb told him. And that included everything. And he also admitted that he knew that Officer Bibb had indeed looked at the phone and saw the photograph on the phone.
Well, he learned that, what he testified, as I understand it, correct me if I'm wrong, is that the detective learned that only after, by that I mean that Bibbs had scrolled through the phone, only after he had applied for the warrant. And he did not amend his affidavit to inform the magistrate judge of that tainted information. So how can we say, so why can't we say there's an independent source when the untainted warrant is executed and the police and the detective discovers what's on the phone?
Actually, Detective Keenan was contradicted in that, because one of the last questions trial counsel asked was confirming that Officer Bibb, that he was aware that Officer Bibb had in fact seen the photos on the phone at the time that he applied for the warrant. And the Officer Bibb he explained that he saw that. He did scroll through the phone because Officer Bibb, according to himself, said that he was not savvy and didn't know how to keep the phone from unlocking. And so by Officer Bibb's testimony to Detective Keenan, he did tell him that he saw the photographs on the phone. Your Honor, we can't be certain what Officer Bibb actually told and what Detective Keenan effectively relied on. We do know from his testimony that he did rely on Detective Bibb's telling him that he saw the photographs on the phone and photographs.
Well, I'm drawing a distinction, and maybe I'm mistaken in this distinction. You'll have to tell me, or the government's counsel will have to address it too. I'm under the impression that what Detective Keenan initially learned from Bibb was that Bibb had seen that one initial photo on the phone. And Bibb was also asking him, now what do I do with this? Can I turn this phone off or whatever? I don't want to lose evidence. But I was under the impression that it was not until much later that Detective Keenan learned that Bibb had seen other photos on the phone. Are you saying that my understanding is incorrect?
Unfortunately, yes, Your Honor. Our understanding, based on Detective Keenan's testimony, and I believe it was page 42, where he admitted that Bibb told him that he had seen photos, not just one, but several photos on the phone. And it was from that Detective Keenan then applied for the warrant. Ms. Chandra's testimony only sought to put everything into context, but it was Officer Bibb's testimony that he had seen photos, multiple photos on the phone, not just the one that he initially saw when he approached, but other photos that was what served as the basis for the application for the warrant. And it was not untainted at that time. And that's why we are suggesting, according to the exclusionary rule, that all of that evidence should have been excluded because it was based on a warrantless search of the phone.
Okay, now you may be making a very valid point here. Let me just be sure I understand. The affidavit, the warrant affidavit itself, if I remember correctly, mentions only one photo on the phone. But your point, if I understand correct, so the magistrate judge knew only of one photo in issuing the warrant. But your point is that the detective, in deciding to apply for the warrant, we could put it that way, was aware that there was more than one photo of interest on the phone, and your argument is that that awareness taints the detective's decision to apply for the warrant
That's correct, Your Honor.
under Murray and whatever.
That's
Okay.
correct, Your Honor. And I'm sorry, my time has expired.
That's all right. I think
Okay.
Judge Beckwith wants
Can
to
I
ask a
ask,
question.
or are you continuing, Judge Glickman?
Yeah, please ask. Yeah.
Okay, sorry, I just wanted to get your take on an argument the government makes, which is, you know, the trial judge did say a couple of times that, it's she, right? She thought that your client consented to the search of the phone, and the government is making the argument that you didn't say that was clearly erroneous in your opening brief. And so, you know, normally I don't know about normally, but we definitely have said we won't consider issues that are raised in a reply brief, and there can be some unfairness if the government can't, respond to it adequately because they didn't know you had raised it. But, you know, I know you did present it in your reply brief, but why should we reach that?
And Your Honor, as I stated in my reply brief, the court has discretion. Under Gaffey, the court has the discretion as to whether or not they wanted to consider it. Mr. Ortiz-Melgar argues that consent was never an issue. The fact that he argued that the entire search was illegal implied that there was no consent, there was no basis for the search, and therefore, by related argument, there was no consent. The similar issue occurred in the case of Gaffey versus United States. In that case, the appellant presented an argument in his reply brief that he did not make at the trial court level. And the Court of Appeals said that because even though it was not explicit, it was a related argument. And the court did have the discretion as to whether or not they wanted to take it up, considering there was no prejudice to the.
But do you agree that if we have this finding of consent from the trial judge that we have to accept it unless we think it's clearly erroneous, which, you know, we don't often find that facts found by trial judges are clearly erroneous. I mean, we do, but it's not a lot.
And in this case, Your Honor, I think that there was a clearly erroneous finding of consent based on the facts when you consider the totality of the circumstances and the fact that Mr. Ortiz-Melgar was seized, whether lawfully or not, and that under those circumstances, he did not feel that he was free to refuse the officer's request or demand in this case to open the phone and unlock it so that he could view the pictures. So we do find that it was a clearly erroneous finding of consent. The government did not even argue or consider the issue of consent. They were relying solely on the fact that there was probable cause for the search, for the arrest, and that there was an independent source or inevitable discovery of the photographs. It was never an issue. No one ever saw it through the lens of consent, and we would posit that was a clearly erroneous finding.
Okay. Ms. Cave, thank you. We'll give you a few minutes in rebuttal. Let us hear from the government.
Thank you.
Good morning. May it please the court. Christina Ament on behalf of the United States. In this case, Your Honors, the Officer Bibb did not violate the Fourth Amendment when he took appellant's phone and escorted appellant to a different area of the metro station to complete his investigation. And even if there was, contrary to the trial court's finding, some violation of the Fourth Amendment thereafter in the officer scrolling through the phone, we would submit that the independent source doctrine readily permitted the trial court to admit the evidence because the exclusionary rule should not have applied. And I'd like to go back to Judge Glickman's recitation of the facts because that was a very articulate and detailed way of analyzing this case under the Fourth Amendment. I would add one thing to the initial knowledge that the officer had when he approached and saw what appeared to be an upskirt photo that he recognized to be a photograph of the victim. Even before he had an opportunity to interview the victim in depth, the victim was pointing out and telling him that appellant was trying to delete a photograph. And that added to the officer's knowledge and gave the officer probable cause to seize the phone to prevent that destruction of evidence. But by the victim saying in an obviously upset and distraught manner, as he describes, that he was trying to delete the photographs, this allowed the officer to confirm what appeared to him to be an unwanted upskirting photo had been taken, and that this phone was the instrumentality of any offense or conflict between the appellant and the victim here. And added to the fact that he recognized that this was a photograph of the victim, given her distinctive dress, that it depicted private areas. There was a fair probability, which is all that is required for probable cause, to permit him to believe that appellant had taken unwanted upskirting photos of the victim here. And the officer was entitled to act accordingly. Given the fact that he
Ms. Emmett, that sounds persuasive. Let me just ask you a question I guess I have about it. When I watched the video, I was really, to be honest, quite surprised how quickly Officer Bibb came up to them and came up to these two people and immediately grabbed the phone out of Ortiz's hand and pulled Ortiz away. And I found myself wondering what he possibly could have learned. I credit the finding that he saw what was on the phone, but what and when he possibly could have learned any of the information that he did. But you're saying that the testimony was, and I think you're correct about this, that when he came up, the victim was saying that Mr. Ortiz was attempting to remove or to delete photos from the phone.
Yes, which would have been, if you think about as he's approaching, he's hearing the words, he's trying to delete photos from the phone, which directs him toward looking at what's in plain view on the phone, all in that short period of time that's depicted on the video. And I don't think there's any question from this record that she was saying things about deleting, not coming right out and describing all the facts of the crime, but saying, don't let him delete that. Don't let him delete it. As the officer's approaching, and she's been waving them over, saying, don't let them delete that, which means as he's approaching, he's learning information that directs him where to look when he gets there.
Fair enough. So that helps support the finding that there was probable cause at that point, rather than a few minutes later. Do you think, just to complete the circle on this, that it makes a difference whether there was probable cause at that point or only a few minutes later after Officer Bibb goes back to the complainant and learns from her what has happened? Do you think that makes a legal difference to this case?
At the end of the day, no, Your Honor, because I think what Terry and Terry's progeny allows the officer to do is to maintain the status quo ante while he dispels suspicion. And so even if the court were to say, and we strongly disagree with this because it's only a fair probability that's required for probable cause, and given that we have a distraught victim who's begging the officer to stop the defendant from deleting her photographs and an upskirt photo, that is more than a fair probability right there. But even if it weren't, the difference is not material because the officer was entitled to detain appellant for a brief period of time and maintain the status quo by stopping him from removing the evidence that he's trying to dispel the suspicion about.
So it justifies, even Rask would justify, in your view, under these circumstances, the seizure of the phone to prevent it from being, to prevent the evidence from being tampered with.
Yes, Your Honor.
But that's not under Terry. That's a separate analysis about concern about destruction of evidence, right? I mean, Terry doesn't say you can seize whatever you want while you're detaining someone.
Well, Terry didn't say that, Your Honor, because the facts in Terry didn't necessitate doing that. But what Terry does talk about is that the purpose or the reason why an officer is allowed to make a Terry detention is to confirm or dispel whatever reasonable suspicion he has. And if he has to maintain the status quo to do that, he can maintain the status quo to do that. And here, it would have made absolutely no sense and in no way would be reasonable to suggest that an officer, in order to dispel his suspicion about upskirt photos, would have to allow the defendant to keep the phone and possibly delete the only evidence that he has while he's trying to talk to the victim and maintain the situation. And I don't think
I'm
that
sorry, I
any-
just want to be clear. The government really wants us to expand Terry to say that it allows police officers to seize objects from people. You don't want us to rely on the separate line of case law about destruction of evidence. You want to say Terry preservation of the status quo allows this? Because that seems really broad and subject to potential abuse.
Well, Your Honor, we would submit that there be no expansion required, but that also the officer was entitled to prevent destruction of evidence with reasonable suspicion. But both of those actually don't matter because it is certainly no expansion to say that a fair probability of an offense existed here. And given a fair probability, the officer was certainly entitled to take the phone in his hand while he continued his investigation and ultimately formally arrested appellant.
Fair enough. So that brings us to Ms. Dave's point that it appears from the transcript that Officer Bibb told the detective that he had seen photos in plural, multiple photos, incriminating photos on the cell phone. And her argument comes down to that providing the detective that information before the detective applied for the warrant taints the decision to apply for the warrant. How do you respond to that?
First off, the passage cited by defense counsel is certainly not definitive evidence that the detective, because that was in response to a leading question where the defense counsel just says photographs, and he answers yes. There are other portions of the transcript where he says that he was not told about any other photograph but the one. And he specifically on pages 46 and 60 says that he did not, that he would have sought the warrant regardless of what the officer told him. So we don't believe that even if he somehow ended up with some knowledge that some other photographs had been obtained, which we don't think that this record supports the conclusion that he was told that on the day, because he actually said the time he learned about it was from the papering attorney, which was well after the warrant process was in play. So what Officer Bibb said was that he called him to find out what to do with the phone in order to preserve it so that there could be further investigation. And then the detective reviews his police report, sees what the victim had reported to him, including all the information about what happened on the train, and says, this is probable cause, and we have an instrumentality of an offense here that we can only search with a warrant. And so, of course, I was going to get a search warrant for it. And he didn't have to have heard, and he didn't hear about whatever the officer did on that day or before he initiated the warrant process. And as the court can readily see from the affidavit, no information about the scrolling appears there.
Mm-hmm. Okay. The trial judge, by the way, I take it, I made no findings on this precise question.
No, Your Honor, the trial court did not make it. Well, first of all, if the court will recall, the context in which the trial court made findings was, first of all, as the government was explaining and had just outlined the standard for independent source, the trial court interrupts and says, well, I don't agree with anything that's been said here with the party's approach, which is that to assume the search was illegal. What the trial court finds is that because appellant consented to the search, to the scrolling, there was no illegality in the scrolling at all. So the trial court is saying, I don't find that there was a Fourth Amendment violation here. But even if I did, because you guys are arguing about it, alternatively, the independent source doctrine applies. Now, in the context of how these findings were laid out, immediately following the government's recitation of the two Murray facts, we would suggest that these findings are adequate to support the independent source finding, because the government had just gotten through saying, well, the record supports the conclusion that he would have sought the warrant anyway. And as I say, twice in his testimony, the detective says those very words. And in fact, the trial court overruled a defense objection to those, suggesting that the trial court understood the relevance of them. And given all of those things, the finding about independent source would implicitly suggest that the court was saying that the requirements under Murray were met.
Do you agree with Ms. Scaife's argument that we have discretion not to decide this case on the basis of consent, of the court's finding of consent?
Your Honor, I think the court, we would submit that the court can affirm on any basis that's in the record. But we would submit that Ms. Scaife has not, even in her reply brief where she belatedly tries to do it, demonstrated any reason why the trial court's finding on consent cannot be affirmed. There's no clear error in the idea that here there was consent to search the phone. I mean, in fact, in the video, the officer hands appellant back the phone while he is sitting unrestrained up against Metro Rail and or against the railing in the metro station. And appellant voluntarily puts his password in and hands the phone back. And we would submit that the trial court found, based on Officer Bibb's testimony in that video, that there was consent, and there's no clear error in that consent. And under Schneckloth, the consent to search would have been legal, even of a cell phone. Even under Riley, there wouldn't have been any legality.
Counsel, can you remind me what is said before the officer hands the phone back to the defendant to put his passcode in?
I believe the only thing that we know for sure that was said was he said that I asked him to unlock the phone.
Yeah, I mean, I have to tell you, I have some hesitation about thinking that this was consent. When the officer has just arrested him, has him sitting on the floor of the train station, has him hold his hands up in the air, grasping the railing, has his feet spread wide apart, has just stuck his finger in the guy's face, and I don't know what he was saying at that point, but I can imagine. And then tells him, unlock your phone. And Mr. Ortiz dutifully unlocks the phone. It doesn't look like a consent situation to me, I guess I would say. And even assuming it's not the product, and I'm with you on this, even assuming it's not the product of an unlawful arrest or anything like that. So I hesitate, and the judge did not make specific findings as to why it was a consent, despite those facts. So, and the government in its brief, and I understand this, the government takes the position the claim was waived, abandoned, but the government in its brief does not argue that, argue on the merits that there was consent here. So I have to tell you, I'm a little hesitant. Why shouldn't I be hesitant under those circumstances to rely on the finding that this was a consensual search of the phone?
Well, Your Honor,
I grant that Mr. Ortiz must have known that the reason he was unlocking the phone at the officer's behest was to enable the officer to look at the phone. I understand the logic of this, but I'm not sure why it's consent.
Well, Your Honor, I would submit that this court owes deference to the trial court's findings, and the trial court here found that he consented to it.
But why do we owe any deference if the court didn't support it? If the court just said it's consensual, but didn't deal with any of the difficult facts that Judge Glickman recited that certainly point in the opposite direction, why should we defer to that?
Because I believe the trial court had actually been able to see the witnesses testify. She had been able to assess how Officer Bibb described the situation, been able to assess the fact that there was no testimony from appellant that he didn't consent. I mean, there was no explanation of appellant's answer to the leading question that was put to him. And based on that, the trial court could have concluded, look, he's not being honest about it, and this officer is being honest about it. And based on having watched both of those and having listened to these arguments, the trial court said, but wait a second, people, he consented to this, and that we should be done without going into all the other factors. I mean, I understand the court's concern, but I also understand that the trial court sat through this hearing and came to a conclusion that there was consent that was supported by the officer's testimony.
Okay. Do you have more you want to address?
If there are no further questions, Your Honor, about this or any of the other issues, I can wrap up. I'm not sure if there are any other questions from the court.
It appears not.
All right, very well. Then we would ask that the judgment of the Superior Court be affirmed.
Counsel, thank you. Ms. Scaife, we'll give you a few minutes.
Oh, yeah, I had to unmute. Just very briefly, I wanted to respond to the government's position on the consent issue. In the transcript, Mr. Ortiz Melgar did take the stand, and he said that Officer Bibb compelled him to open his phone, which suggests, or actually it's very clear evidence that he did not consent, number one. Number two, we do believe that the trial court's finding of consent was clearly erroneous under the circumstances, whereas the court noted Officer Bibb physically separated the two. Even conceding that he was under arrest, he was therefore in police custody. At that time, any actions or words that would have evinced consent, in our view, was negated by the fact that this was all an unlawful seizure and an unlawful search. Mr. Ortiz Melgar arguably did not feel that he could tell the officer no in his particular predicament. He felt that he had to, in fact, comply with the officer's demand, not a request, but a demand to unlock the phone. And for those reasons, Your Honor, we submit that this was not a consensual case. The trial court found that Mr. Ortiz Melgar was not in custody when in fact he was, whether it was lawful custody because of an arrest or an unlawful custody because of a seizure. He was seized, he was in custody, and did not feel he had any ability to disobey the officer's request. The only other thing I would argue is that it's the issue of the other photographs and videos being used at the sentencing. Our argument is that there was no context for those other photographs. There was no proof of authorship. There was no proof of anything with regards to those photographs except that they existed on Mr. Ortiz Melgar's phone. And the court improperly used that as a basis to order him to sex offender treatment as well as a mental health evaluation. And we submit to this court that that was improper improper assumptions made on behalf of the court about Mr. Ortiz Melgar's character, his priors, and therefore, if nothing else, there should be a remand for resentencing to remove those particular conditions of supervision. And with that, Your Honor, unless there are any other questions, we would submit to the court.
Counsel, thank you both. The case is now submitted.
Thank you, Your Honor.
And we will call the second case, Juwan Champion versus United States.
Okay, Your Honors, I'm bringing the next case in.
Thank you.
Thank you.
Thank you. We've called the case of Champion versus United States. Ms. Ernest, counsel for appellant.
Good morning, Your Honor. I apologize, there were some technical difficulties.
No
Good
problem.
morning,
Go
Your
ahead.
Honors. I would like to reserve 3 minutes of my time for rebuttal.
Mhm.
May it please the court. My name is Robin Ernest on behalf of One Champion. We raised 2 main issues on appeal. I'd like to get to both of them, but I will start with the trial court's denial of Mr. Champion's motion to suppress because that affects both of the issues in this case. Mr. Champion's conduct in having wide eyes and apparently holding his breath did not permit officers to singularly order him out of his Lyft taxi at a traffic stop of the unrelated driver for failing to signal his turn. The
Ms.
government.
Ernest,
Yes,
I'm
ma'am.
sorry to interrupt you right off the bat, but
Go right ahead.
don't officers have the authority to get passengers out of the car when they've stopped it? Do they, why do they have to have specific, I agree there are some interesting issues about Mr. Champion's nervousness and so forth, but I had understood that people could just be gotten out of the car at a stop like this.
So the Supreme Court in 2007 in Brindleland is the case that sets the tone for that. And basically the case was deciding when the passengers in a car are seized. And Justice Souter, writing for the court, set the rule that the Fourth Amendment, that they're seized at the time that they are stopped by the police, and when a reasonable passenger would feel that they did not have the ability to leave. And the officers at that point would have, on the facts of that case, authority to order all occupants out of the vehicle as a precautionary measure for safety concern. This court in 2013, I believe, writing in Zanadar versus United States on similar facts, reinforced or underscored Brindleland and said on facts where all of the occupants were ordered out of the vehicle and the officer testified that it was done as a safety concern, that was permissible. The facts are different here, however. In this case, only one individual was ordered out of the car, and also it was a common carrier vehicle. There's some concern by Justice Souter in writing in Brindleland and footnote 6 whether or not that would make a difference. We think it makes a difference here. Moreover, there was absolutely no testimony that the ordering the singular passenger out of the car was done for safety concerns. In fact, even though the trial court find that is not what Officer Ackgard testified to. He only
What do we do with the,
That's
isn't it?
subjective.
Oh,
Sorry.
you go.
That's a subjective question, right? What was in the officer's head? But if we go back to sort of the reasonableness of the officer's conduct and whether it's reasonable for officers conducting a traffic stop to ask individuals in the car to exit. What I understand you saying is that it's reasonable for police to operate under an all or nothing rule. Either everybody stays in the car or everybody gets out of the car. But
Yes.
some in-between rule is not reasonable under the Fourth Amendment. And I'm not sure that I'm following that analysis. Can you explain to me why you think that has to be the objectively reasonable rule?
Well, I think that Justice Souter was, as he says, I think in footnote 6, he didn't want to authorize officers on a roving patrol to just stop people at a traffic stop and then, order them individually out of the car as a sort of an investigatory search, which is exactly what happened here. But I think that's the first point. And the second point also, in a common carrier situation, there is not the assurance that there's, or even the implication that there's an association between the persons that are in the car. And therefore, it is probably not as safe to order them individually out of the car because of potentialities as what happened here. And that is, in this instance, the middle passenger, when the defendant was ordered out of the car, planted a gun in the property that he left in the car. So it is consistent with the justice's concern for officer safety that the officers are authorized to order all occupants. And of course, both in Brendelin and in Zanadar, the court talks about ordering all occupants. That includes the driver out of the car, not just all passengers for officer safety.
So if the officer stops a car such as this one, and one passenger in particular seems to be acting in a way that the officer thinks is suspicious, makes him look nervous, and the officer thinks, I'd better get this passenger out of the car. You think you think Justice Souter would say, oh, well, I think that's problematic under principles and unlawful? I mean, it sounds like this is a case in which the officer was a bit of a minimalist. He said, I'm not going to order everybody out of the car. Most of them I don't seem to have any concern with, but I do have a safety concern about this one person. Maybe I'm right, maybe I'm wrong, but I'm not going to take any risks. The Supreme Court says I can order them out of the car. So I'm having a little trouble seeing what's wrong with that.
Under a totality of the circumstances analysis, I think you look to the fact that this is a common carrier, so there's no association between the driver.
You've never heard of people in common carriers robbing the cab drivers or taking the cab to their destination to commit a crime?
Actually, I have.
Or just going from one place to another with a weapon on them.
But that's not the facts here, and that's not the reason why.
Have you found any cases in which that support your position? Let's say that post-Mims, post-Brendelin cases that would support the position that the officer violated Mr. Champion's Fourth Amendment rights by ordering him out of the car in this case?
I don't think that this jurisdiction has ruled on the facts here. I don't think that I could not find any cases in which the court had ruled on a common carrier situation, which is what we have here.
Have you found any cases from any other jurisdictions that support your position?
I did not find any cases from any jurisdiction either way. The closest case I could find was NRA JM from this jurisdiction in 1991. And that's when police officers approached a 14-year-old boy on a bus and ordered him to, show his shirt as to whether or not he was carrying guns. And in that case, the court reversed. They found, though they talked about that the test for search and seizure would essentially be the same, whether or not a reasonable person would have felt that they, had authority or had the ability to deny the request. They did reverse on those facts. That's the closest case that I could find. I don't know that any.
Well, let's talk about the question on the assumption that the officer did not violate Mr. Champion's rights by ordering him out of the car. Where does that leave us?
that leaves the search, whether or not he had probable cause to search the jacket once once he ordered him out of the car. The Pele,
You think probable cause was required?
the court found found probable cause. That I believe that
The
was
court
court's
found
finding.
probable cause, but the government seems to be arguing that there was reasonable articulable suspicion to do, a Terry search of the car under Long.
I don't believe it's the appellant's argument that simply the blading, which the defendant did, government's term, turning and taking his jacket off before he exited the vehicle, was sufficient reasonable articulable suspicion or probable cause for the search that followed. It is not illegal to not want the police to have access to your stuff. Who knows what he could have had in that jacket? It could have been bad poetry. It could have been anything that he had a right under the Fourth Amendment not to have the police review at the time. He had done.
But we do have case law treating blading as suspicious, don't we? Are you saying the question is, but suspicious as to what?
Yes, and I am also emphasizing again the totality of the circumstances in this situation. You had an individual with other passengers in the car. He bladed himself. I'm just going to keep with the government's term, in a fashion that was unique to allowing the middle passenger then to insert the gun in the inside pocket. It would not reasonably have gotten there any other way. If it was already in his pocket, then he would have reasonably just taken off his jacket the way most of us do. Turning around, it allowed the middle passenger to plant the gun inside his inside pocket. We know that the middle passenger exercised some sway over the defendant, because at the very beginning of the video by Officer Akkar's arrest, you see the middle passenger is holding the white phone, which we know is his phone, which we know is the phone that has the photos of him with a gun and also of the gun. But when Champion is ordered out of the car, in that video sequence, we see that Champion is now holding the phone. So there was some conversation, there was some pressure, there was some influence by the middle passenger on him to take the phone.
Just to get back to the how suspicious his behavior was, in the video, I think it's the first video that was shown. Maybe it was the second. Maybe it was the second one. Is it McCarthy? It really does seem like. I mean, first of all, you can see the turn, and it does seem like the officers are like, "What are you doing?" And they even say, "I don't know if the sound is part of our record." That's another question I have, but I think it is for a suppression hearing, maybe, and isn't for the trial, something like that.
Correct.
But you can tell they even use the word concerning, that they found it suspicious and said they thought he was trying to hide something.
The video also shows that even before that, the officer has his hand on the door handle. He's opening the door. He's going to open the door for a pat down of this defendant. Regardless, the blading was just, I think, not what they expected, and something that they talked about in that regard. But the intent of the stop was to an investigatory stop for looking for guns, as opposed to just a routine traffic stop. They followed the taxi for 2 blocks before they ever stopped him. They didn't issue him a ticket. It took some time for them to issue even a warning for him under some reluctance. So it was clear from the video that they were not concerned about the traffic stop, that they were concerned about, searching for guns. And If there are no further questions on
Well,
this
I
issue.
do,
Okay,
I do have a question. So if we assume that under Long, the government needed reasonable suspicion, like particularized suspicion, that someone in the car was armed and dangerous or whatever they're searching for, you know, is a weapon, something like that. Do you think that does the evidence need to be particularized to that? Like, does the government need to have some reason to think there's actually a gun in there, or is it enough that they were suspicious that Mr. Champion was trying to hide something, which would obviously be something he wanted to hide, which could be drugs or gun or whatever?
certainly. Well, the test, of course, is the totality of the circumstances. Under the totality of the circumstances, you do need reasonable articulable suspicion that a crime is being committed by this particular defendant. All they had was that he looked nervous, that he was appeared to be holding his breath. I don't even know how they make that assessment. So at this juncture, they don't have that. On these, on the totality of the circumstances as they were present at the time of the search, they did not have particular concern that he had a gun, as opposed to the middle passenger having a gun or anyone else having a gun in the car, which makes all the more reasonable.
Let me ask you a question, Ms. Ernest. Do you think, here's the way I sort of look at this case. There's no question in my mind, to be candid with you, that the police had the authority to ask Mr. Champion out of the car, to order Mr. Champion out of the car. On the other hand, it's not immediately obvious to me that they had any reasonable articulable suspicion until he started appearing to conceal something, to investigate him. They just wanted him out of the car. Now, when he starts moving as he does, I think the officer had reason to believe he was trying to conceal something. One question I have, and something you said triggered this thought in my mind. One question I have is, if the officer has reasonable articulable suspicion to believe that the person is trying to conceal something, but does not have reasonable articulable suspicion that a crime has been or is being committed, what does that allow the officer to do to investigate what's being concealed? That's sort of part A. And then part B of my question is the one that Judge Beckwith asked you about, and I don't think you really answered. Suppose we think that the officer has reasonable articulable suspicion to believe that Mr. Champion is hiding something, but the officer does not know what it is. It might be a gun, but it might be other contraband, or as you put it, it might even be innocent stuff that, for whatever reason, Mr. Champion does not want the officer to see. Under Terry, we normally say that the officer must have reasonable articulable suspicion to believe that the person is armed and dangerous in order to, or to believe that the person might be, the government would say, armed and dangerous to justify either a pat down or a Michigan v. Long search of the stuff in the car. If the officer knows only that he's hiding something that might be a gun, does that rise to the level of what the Supreme Court, of the suspicion the Supreme Court has said is required? So you can address either of those two questions that I've asked you, ideally both of them, if you remember them.
Thank you, Your Honor. I will certainly do my best. No, is the answer. We do not believe that he had the necessary reasonable or articulable suspicion that a crime was being committed by this individual, that this individual had a gun at the time that he merely saw him turning around in the car. Nothing more, but his eyes were wide. Distinguishable from the other cases, he didn't make any furtive movements consistent with hiding a weapon. He didn't bend down and put something under the seat of the car. He didn't pass something off to someone
Well,
else.
I have to tell you there, I don't think your argument gets you very far. I think we have to accept that a reasonable officer perceived him to be concealing something, hiding something.
But
And
is this something
I-
criminal? Sorry.
Well, that's, now we're getting to what I think is the nub of the issue, or maybe one of them.
Thank you, Your Honor. I'm sorry, I didn't mean to interrupt, but exactly, we all hide things. You know, the Fourth Amendment, it lets us hide things. We don't want to put stuff out, you know, publicize everything. Why should we? Why don't, you know, we have that right? So it's whether or not he was concealing something of a crime. Was he concealing a gun? Was he concealing? And at this juncture, they do not have that information. At this juncture, the officer he was already asking him out of the car, as you said, he had the authority to do. He said that he had concerned about his burn. On exiting the vehicle, he could have asked him questions which could have led to information as to, you know, what it was that made him turn in the method that he did. But at the time that he immediately opened the car door, asked him, "You don't have any guns on you," and then immediately passed him off to Officer McCarthy for a non-consensual search. At that point, he did not have sufficient information. In fact, the response that Defendant Champion gave was reasonable. You know, why'd you take your jacket off? He said, because there was weed in it. And McCarthy's response is, oh, we don't care about that. And so, you know, at the point, and at this point that he's making that response, the officer has already seats the jacket. The jacket is actually being held by the middle passenger, and the officer has to say, you know, let go of that man so I can see it. So we don't know how the gun got in that jacket. The middle passenger
That's a factual issue, which is not a Fourth Amendment issue. So let's focus on the Fourth Amendment issue.
Okay. At that, under a Fourth Amendment analysis, the totality of the circumstances, the facts that, you know, that the trial court found do not equate to finding that there was a reasonable articulable suspicion or probable cause for the search. There was simply not the evidence that the defendant had committed a crime by not wanting officers to see what's in his jacket.
Okay, let us hear from the government, and then we'll give you a few minutes in rebuttal.
Thank you, Your Honor.
Mr.
Can
Snable?
we ask you, Ms. Ernest, to mute your mic while the
Sure.
government is speaking?
May I proceed, Your Honor?
Yes, you may.
Thank you. May it please the court. Good morning, David Sable on behalf of the United States. Just briefly, Your Honor, with respect to the questions that the court was asking about getting out of the car, the Supreme Court, of course, decided this issue in 1997 in Maryland versus Wilson, the follow-up to Pennsylvania versus Mims. And in that case, Wilson was actually the front seat passenger. There was a driver and a backseat passenger, and the officer in Wilson got Wilson out, but not the backseat passenger. And the court found that safety concerns meant that if the stop was legitimate, the officer could get the passengers out, and rejected the dissent, which said, well, we know we need a particularized suspicion in order to get the passenger out. So that was established in Maryland versus Wilson, and Brennan had to do with standing. So there's no question in this case, we concede that appellant has standing to challenge the legitimacy of the stop. The legitimacy of the stop, the traffic violation, of course, is not at issue on this appeal. It was an issue at trial, but appellant hasn't briefed it. Turning to the reasonable articulable suspicion to frisk the jacket, before I address Judge Beckwith and Judge Glickman, your question about whether it's contraband versus a gun or something like that, I'd like to just generally set out what the court found. The court's findings are very helpful here because the court credited Officer Akhtar, who was corroborated by the body-worn camera, when he said that first of all, I noticed nervousness, wide eyes, open mouth. He looked nervous. And that's why he only got one of the 4 passengers in the car. It's a very crowded, by the way. You've probably all seen the video. It's a small Hyundai. And there are 3 people in the back seat and 1 in the front seat. And then there's the driver. So they're all jammed in there. And he noticed.
Counsel, is nervousness synonymous with a safety concern? I mean, maybe Wilson just says that it is and we're stuck with that. But just because someone is nervous, it doesn't necessarily translate to me into a reasonable belief that the officer is, it might be perceived as the occupant of the car being fearful for his safety, but I'm not sure it works necessarily the other way.
Well, this court, getting somebody, you're talking about the frisk, not getting out of the car, I gather, Your Honor, is that what you're saying?
Well, if
we
you're
don't
talking
need-
about, yeah, I guess getting out of the car and the frisk, if the basis is the nervousness, if the basis of the attention on the defendant is just the nervousness, I see a gap still between the nervousness and the need to perform a frisk, right? The Terry frisk needs to be because you think that person might be armed and dangerous, right?
Right. It's only one small part of the basis for the frisk, but we don't need anything to get him out of the car, although the court did find particularized facts justifying getting this particular person out of the car. But
I think that's what's so confusing about it, Mr. Sable, is that there's a lot of focus on the suspicion, him being particularly nervous, which seems like it's directed to the what's needed to get him out of the car, which, as you said, isn't needed because it's basically now a bright line rule under Maryland versus Wilson. But so you're just saying that part of it is just part of the calculus that you add to his weird behavior, his turnaround and all of that. Is that the relevance of it?
Right. It's too long of a wind up from my totality of the circumstances. I think it's just, so we have the nervousness and then we have the failure to get out of the car. He knocks on the window and instead of getting out of the car, he turns around in this jammed car and engages in what the court found was an obvious and blatant attempt to shed his jacket. And while he's hiding the left side of his coat, and as Officer McCarthy says, it looked like you were trying to hide evidence. That was obviously very concerning to us. And so at that point,
can I interrupt you for just a tangent little question? I hope you remember where you were, and I'm sorry, but I always wonder about this. So we can see the video, and it's helpful because that would be hard. The description of what he did would be hard to envision if you couldn't see it. But and I think I don't know. I won't speculate on whether we would see that differently than the trial judge did. But one thing we might see differently is the nervousness of Mr. Champion and how the officers testified that it really stood out from the others who were not nervous. Now, if we happened to look at that video and not see that, what are we? I've seen some cases that say we're looking at the same video the trial judge looked at, but it's not really the trial judge as much as it is the officer. The officer was there. You do know what I'm asking? Is there any less deference or different kind of deference if we're looking at that video? And as I actually was, and I was thinking,
you can't quite see it.
Yeah.
I know you can't quite see on the video exactly the nervousness that Officer Akhtar is describing. And what the court said was, well, he testified to it. I have the video, which corroborates everything that is visible, and that's enough for me to credit. So it's a virtually unreviewable credibility finding. And I think we both could recognize that what he could see as he was watching the passengers in the car was not necessarily the same as what we can now see on the video. And so, and if there were any doubt about that, we have the fact that he just got the one guy out of the car and there were 3 other passengers in the vehicle. So all that the court found was a package that led the court to credit it. So we would be
And
under a clear error standard here. So I guess the answer to my question, Your Honor, is it's a clear error standard.
Okay, I also got the impression that it wasn't so obvious to me, maybe this comes right back to what you just said, that the officers were just planning to get Mr. Champion out. I mean, they end up getting everybody else out, but that is because they find the gun, presumably. But it seemed like a stop that had a. Is there anything in the record that supports that? I guess just besides his testimony, I don't know. Does he actually testify? I was only going to get this guy in the back seat behind the driver out. I wasn't going to get anybody else out. Sort of looks like they're going to get everybody out.
I don't know. I don't know what would lead the court to say that, Your Honor. What I know is that he testified as to why he got him out. I don't know if you're referring to a discussion between the officers was never presented to the court, was not admitted into evidence, somehow seems to have made its way into the record on appeal, having to do with the way our office interacts with defense counsel and with, suppression exhibits, which weren't clipped. But there was some conversation which was elliptical, but I don't really know exactly what the officers
Okay,
were
it doesn't really matter, and I apologize for the tangent, but I was curious.
Well, I mean, appellant raised this issue in her reply brief, and I wanted to just say to the court that this was not briefed, it was not presented to the trial court, and in fact, it's not really properly in the record on appeal. You had asked the exhibits, the suppression hearing exhibits were only admitted up to like the first 2 minutes, and that's on page 18 and 25 of the suppression hearing transcript. But going back to the totality of the circumstances analysis, if I can.
Yes.
So the court made a very specific finding about, after being ordered out of the car, instead of getting out of the car, he engages in this obvious and blatant attempt to shed his jacket where he's hiding his coat. And so the court finds that this is very suspicious, that it is more suspicious than a furtive gesture. Now, we get to furtive gestures. And so what does it mean to make a furtive gesture? Judge Beckwith, you talked in Jackson a lot about furtive gestures. There are some furtive gestures where somebody's reaching under the seat. That tends to support probable cause or RAS for a frisk. Jackson was somebody waving their hands in front of the car. They probably had hit some drugs in the steering wheel, but that wasn't enough for a frisk of the steering wheel. We know that the furtive gestures in Glover, which was Judge Glickman's case, that would have been.
Can I interrupt and say I talked about furtive gestures in another case, and furtive seems to me like you're being super secretive, and in this case, he's not being super secretive. He is in open view, taking off his jacket, and it is really suspicious. It's not furtive at all, right? Like he's not ducking behind anything to take off his jacket. It is out there for all to see. So, I mean, I think we can take the point that, okay, he's nervous and he's taken off his jacket immediately upon being ordered to exit the vehicle, which sends a message loud and clear to the police officers that he doesn't want to be wearing the jacket when he gets out of the car, presumably to be frisked. And I think the question then becomes what Judge Glickman was asking, which is, okay, do the officers have a basis to think that he is armed and dangerous, right? Because if we're under a Terry framework, right, there's the initial sort of, can you stop, can you detain, can you ask questions? And then there's the, can you search? And the search part of it is tied to safety and whether or not you have particularized reason to think that the person is armed and dangerous. And what I understand is that everyone thinks that he's hiding something, but what? You know, I mean, these kids, if I look at the videotape, I see, you know, these kids in a car. I think the defendant is just 18, he tells the officers, right? So who's to say that he doesn't have a pack of cigarettes in his jacket that he doesn't want anyone to see, which he's not allowed to have because he's under 21? I mean, you know, why do we think that it is a gun? Why do we get to search this young man? That's the question for me. I have no doubt that what he did was suspicious. I appreciate you not calling his removal of the jacket blading. He turned his back fully to the officers and removed his jacket. It's no doubt. It raises eyebrows and everyone's wondering, what is he trying to hide? But the question is he trying to hide something that could hurt the officers? And that I think is really difficult.
I think my answer to your question, Your Honor, would be in a couple different pieces. First of all, the court made findings which are different from what the way the case strikes you, apparently. The court found that this was a very suspicious gesture giving rise to, in fact, the court thought probable cause based on the suspiciousness of the gesture. And the court
probable
thought
cause
that this
as to what? I'm sorry, because I'm completely agreeing with the trial court that it was suspicious. So I don't think I diverged from the trial court on that. What did the trial court say it was probable cause to? Probable cause as to weapon or contraband?
The court said it was very suspicious based on the officer's testimony that this kind of behavior, which the officer described as blading, was consistent with hiding of weapons. The officer described it as hiding of weapons. The officer did talk about contraband as well. But the court, and so the officers, the court found it was a very suspicious and dangerous move, more so than the furtive gestures that this court has found gave rise to RAS to Frisk and Glover and James. And but wasn't the case in Jackson, which is a case that appellants were relying on. And then we also have a number of, I'm sorry, I'm going to say blading, but blading cases outside the jurisdiction where blading is a factor that gives rise to RAS to Frisk. And then, of course, we have the Singleton case.
I'm sorry to interrupt, but I guess what's unique about the record here, I mean, maybe it's not unique. I forget those cases as soon as I read them, but it seems to be, we have testimony from the officer and finding by the trial court that indicates the suspicion is for, you know, something, maybe a gun, like it might be a gun or a gun, contraband or a gun. And then, you know, so the question is, how specific does this suspicion have to be?
I'm sorry, Your Honor. Yes, and I thank you for reminding me of that point, which is that the officer isn't required at the RAS threshold to negate all possible inferences of bad poetry, cigarettes, you know, a bottle of wine. It's simply enough that it gives rise to reasonable specific facts that it could be a weapon. And the fact that he's engaging in this that is consistent with his experience recovering over 70 weapons, observing behavior like this, the court recognized this in Singleton, for example. This court it was a blading case, didn't use that term, but that was a blading case as well, where this kind of behavior gives rise to a basis to search or to frisk, I should say.
Are there
This
any
is
cases?
the question for
Oh,
me.
sorry.
I mean, it seems to me there are two approaches to this. The Supreme Court has said there has to be reasonable articulable suspicion that the person is armed and dangerous to justify a frisk. So does that mean that any time the police see someone appearing to hide something, and the something could be a weapon, in other words, the possibility that it is a weapon has not been ruled out, which it could be in some cases because a weapon couldn't fit into that compartment, for example. But that's not true here. Then that is enough to satisfy the requirement of reasonable articulable suspicion. Or does the Supreme Court require something more in the way of pointing to the notion that this is a weapon? The blading is suspicious, but blading really doesn't tell you whether it's a weapon or some other sort of contraband. It just doesn't. You could act the same way, blading yourself to avoid the officer seeing what's in the jacket pocket. And I understand this was a potentially dangerous situation, because if it was a weapon, he was in effect giving the weapon to a Confederate, potential Confederate, in the car, who could do, God knows what with it. So I understand the officers have a lot of reason to be careful and to do all these things. But I still want to understand what the legal standard is, because courts have gone different ways on this. And I honestly do not know how much is required to satisfy the requirement of reasonable articulable suspicion that the person is armed and dangerous. I'm also going to later get back to the other question I asked Ms. Ernest, but let's focus on this one for now. Okay.
Sure, Your Honor, I think you're
It
right.
might be a weapon.
The frisk inquiry, I'm sorry. The frisk inquiry focuses on dangerousness. So it's not necessarily just other contraband, but it's reasonable articulable suspicion. And the government is aided here by testimony from the officer, which the court credited, that this behavior was consistent with hiding weapons. And when you think about it,
the court said consistently or contraband.
sometimes
The court did not say exclusively weapons.
not exclusively weapons, but it said including weapons. And the officer testified that he had seen weapons many times hidden in this fashion. And in Singleton,
let's suppose the officer had not given that testimony. Let's say it's a rookie. The officer just says, look, here's why I frisked him. He was hiding something, and it could have been a weapon. I couldn't rule that out. And my life is more important to me than, lots of fine points here. So I frisked him. Now, is that, and if you said to the officer, well, what were you investigating? Well, I was investigating nothing until he started acting suspiciously like this. And then I had reasonable articulable suspicion to believe he was hiding some sort of contraband. So I have something to investigate. Okay. Now, if that's the testimony, reduced to its essentials, in your view, does the Fourth Amendment permit that frisk?
I think I would say yes, Your Honor, because I'm looking at Glover and James. Those are gestures. There's no evidence that that was a gun versus cigarettes versus bad poetry versus drugs. The police are allowed to look under the seat in James and Glover, whereas they weren't allowed to look in the driver's wheel, in the driving wheel. I don't know why I can't say that word in Jackson. So there weren't. That was the dangerousness. It was the nervousness. In James, it was a failure to comply with a command, which is an important difference here. This isn't just a gesture on the street. The officer orders him out of the car. He doesn't get out of the car, but he engages in this very dangerous behavior. And in James, this court said, it is also significant that at the time appellant made his furtive gesture, he was aware that the police were pursuing him. So that made it even more suspicious. And there weren't facts that said, oh, well, this has got to be a gun in Glover and James. It was sufficiently dangerous to give rise to RAS that it could be a weapon.
It's interesting because the Second Circuit just came out with a decision in a case called Weaver last month, where it was answering Judge Glickman's question about, is it just enough to say we can't rule it out? And the Second Circuit said no. We agree that officers are not required to rule out every innocent explanation, but that does not mean, as the dissent would have us believe, that any conduct consistent with or possibly suggestive of weapon possession satisfies the reasonable suspicion standard. So in that case, it was very similar to this one where there was a car stop and they thought that he was hiding something. The driver was hiding something, but they really didn't have a reason to believe that it was a weapon. And the Second Circuit said that search violates the Fourth Amendment.
Well, you had me at a loss, Your Honor. I did update blading cases, but I didn't update all gun cases this morning, and I didn't see that. I know that there are a number of cases that are in our brief about blading behavior or this kind of behavior,
Right, but
and then we have
I
Singleton.
find blading to be less helpful, right? Because it's just a term of art, and I actually think it doesn't. I mean, blading to me just means that you're turning your body so you can't see. You're being on the narrow side, so you can't see the opposite hip. I mean, here the facts are even better for the government in that he turns his back full on to the officer, removes the jacket and tosses it into the car. He does not want the police to see the jacket. I give you that.
Right.
And
well, so that's why blading is like furtive gesture. I mean, it's a term of art, and you have to drill down a little bit to see exactly what it means. And that's what Judge Beckwith, you were talking about in Jackson. But when you look at the court's findings here and about the suspiciousness of this gesture and what the court has said about furtive gestures in other circumstances, we are above Glover and James. We are above those cases, and we're even above Singleton because of the fact that he's making this gesture in response, although he didn't see a bulge, he's making it in response to an order from the court. And so we are well above those cases in terms
Mr.
of basis
Sable,
for a frisk.
you know this case law better than I do. Is it your impression that like we've kind of gone in two different directions? There are two different lines of cases. Some saying whatever the suspicious behavior is has to be viewing it as relevant, that it looks like something that might involve that involves a gun, something related to a gun, and some, like you keep saying, James and Glover, apparently are just more generic. Have we gone in two different directions, or are there cases that are different from James and Glover that you've run across? And in James and Glover, was this issue, litigated or focused upon?
I don't know that I have a good answer for you, Your Honor. I'm sure my suspicion is that if I go back and look at these cases and try to focus on this particular question, that there has been language about the particular dangerousness of gestures where it looks like you're hiding things where they could be, a weapon is likely to be concealed, a waistband, or hiding something under a seat. I mean, it doesn't exclude other possibilities, but some gestures are more potentially dangerous than others. But what we have in this case is it's consistent with hiding something big, because obviously if it's just something small, it's in your coat, you're not going to see it when you get out of the car. It is consistent with something more visible, bigger than a pack of cigarettes. But in any event, the court found it was very suspicious, and Officer Akhtar had found it to be consistent with recovery of weapons and contraband, as Judge Easley points out.
Do you understand what the judge was getting at when she relied on a probable cause standard instead of reasonable suspicion? And am I right in saying the government isn't really running with that theory?
We didn't brief that, but obviously the standard answer is that you can affirm on that ground. You don't need me to brief it to do that. And I have to say, and listening to the court today talk about Michigan versus Long, and I was thinking about Gantt searches, that it might have been a mistake not to brief the PC angle on this, when you look at some of these cases. But I think the court thought it was so strong that it found PC, and then
I'd have to say, if I could interrupt you, I'd have to say I don't quite understand that, because I don't see how the police could have said before they searched the jacket that they had probable cause to arrest Mr. Champion for anything. That which is the premise of saying that you have probable cause.
I understand.
Nor do I think it's hard for me to think alternatively that they had probable cause to do a car search based on, if that's what the judge was thinking, based on what they had seen. That I think is, I mean, even recognizing what Ms. Amen said earlier in the previous argument, that probable cause just means a fair probability. It's hard for me to think that you could actually make an arrest or a search of the car based on what they knew before they looked inside the jacket. Do you disagree with that?
Well, I just so I'm clear, I think the court was just talking. They didn't search the car; they just searched the jacket. So if they frisked the car, frisked the jacket, or searched the jacket, those would be two different ways of
conducting a frisk.
Yes.
Yeah, right.
Yes. In this case, it was a plain feel. It was a the gun was really big. You've seen the pictures. It was a Glock 9, but a Smith & Wesson 9, but it had the extended magazine. So from top to bottom, as opposed to the length of the barrel, it was about 12 inches. So to have that concealed in the pocket of a coat, it's a very significant bulge. And so I think that's why they didn't discuss bulges at this hearing, but I think that's why Officer Akhtar was testifying that this kind of behavior is generally consistent with weapons, because a couple zips of marijuana in a coat are not going to stick out. You don't need to hide that from police. You don't need to turn your body from police. And the other reason,
I feel like I've seen transcripts where witnesses for the government testified otherwise, but I hear you. It seems at least more likely. But can I ask you about you mentioned the plain feel. If the officers have reasonable suspicion to do this Michigan versus Long kind of search, which I mean, is that, I'm assuming that includes the jacket, and that's what I understand you say. That I think they searched the whole car later, but probably after the arrest. But do they need it? Can they go into the container of the pocket, or did they need to do the plain feel approach? You know what I mean? And it's like the officer did pick up the jacket and feel that there was a gun, but if he had just gone straight into the pocket, would that be consistent with Michigan versus Long?
I'm not sure, Your Honor. I didn't brief that. I don't want to speculate.
Okay.
It was never really challenged. It was such a big gun in a cloth coat that it didn't seem like it was an issue that immediately upon picking it up, and you can see from the video, he picks it up and then he puts it on top of the car and says 7-Eleven, which is the code word for the officers that it's a gun. So I don't know.
Okay. I think you were going somewhere else when we interrupted you.
You've taken me far afield.
There are a lot of interesting issues in this case.
Again, I wanted to make the point that because blading is a term of art, just as furtive gestures are a term of art, finding RAS in this case doesn't open a broad door to finding RAS every time some officer says the word blading. They're very specific facts. They're difficult to match these patterns. And the findings in this case are very strong by the judge. And unless they're clearly erroneous, I would submit that under this court's existing case law, not even going outside to looking at blading cases, it's not error to find RAS to frisk the jacket. I don't think I have more to say about the suppression issue. If the court didn't have questions about the second issue, then we would ask the judgment of the Superior Court to be affirmed.
Okay, thank you very much. Let us hear from Ms. Ernest in rebuttal. Ms. Ernest, we'll give you 3 minutes.
Can you hear me now? Thank you, Your Honors. I just want to briefly address something that Apelli said, and at the very end, of course, this court's review of the facts is clearly erroneous, but this court reviews de novo whether or not there was a violation of the Fourth Amendment, and I think that that's sort of where we are here. Also, to point out, there was lots of discussion or lots of characterization of the of the movements as being dangerous. That's not a term that the court used. The court never said that it found that that Mr. Champion's actions were dangerous, or that the officer testified that they were. Her words were he's attempting to hide contraband and call into question, that's what she was referring to when she found that there was probable cause. I would like to turn now to the second issue, which was that the trial court erred in excluding as irrelevant third-party perpetrator evidence in support of the defense theory that it was someone else who possessed that gun, specifically that the middle passenger had motive and opportunity to possess the gun at the time. The items that were excluded were relevant under Johnson standard. They were relevant applying a 404 standard of relevant. They were relevant because they would raise any evidence. They would provide any evidence of the possibility as to whether the middle passenger was a third-party perpetrator in actually possessing the gun, or would provide evidence that would lessen in the jury's mind an element for finding that it was Mr. Champion who possessed the gun, or it would raise reasonable doubt in the jury's mind that it was Mr. Champion who was the one who actually possessed the guns. So
but isn't this a situation where defense counsel kind of dropped the ball if she, I think, really wanted to get this this evidence in because Judge McKenna, I think Judge McKenna made this ruling, or is it Judge Dason? But Judge McKenna, Dason, sorry. She, said, come back and give me more on this. I'm not excluding it out of hand, but I'm not convinced yet. And so come back and give me more. And defense counsel never did.
Initially, when she was trying to get the information, the reference to the second photo and the body-worn camera video that addressed the officer's response to finding it for her opening statement and oral argument, then you're absolutely correct. Judge Dason said, at this juncture, I'm not going to allow it. And then during the trial itself, during the testimony of Officer Ackar, he tried to get in the photo once again and was told that it was irrelevant. Judge Dason said it's not the same gun in photo number 1 as in photo number 2. The gun in photo number 2 to me appears to be silver. All of these are, facts that the jury.
But at that point, isn't it just like a 403 balancing kind of thing, and the judge can make that call?
The 401 is a rule that this court forwarded to in Johnson and found that if the evidence would fit a 401 analysis, that it should come in as relevant. She wasn't asking it to be admitted at this point. She was just asking to introduce it. She was asking to get before the jury and then have them make a determination as to whether or not the photo of the guns were too dissimilar for it to be relevant. This is what juries do, or not. But so she excluded that, and having excluded the photo, and again, this is photo number 2. This is the photo of the middle passenger, appears to be in bed with a gun, whether or not it's the same gun. And so just sort of House of Cards, a domino effect in excluding photo 2 was irrelevant. Then she excluded even any testimony by the officer that he found another photo, right? So you wouldn't even allow defense counsel to ask whether or not there was another photo. Wouldn't allow defense counsel to ask the officer what their reaction was on finding the photo. All of these things were essential to her defense theory of the case, which was that it was the third party. There was a third party there who had motive, who had opportunity because he was right beside Champion as he exited the car. Opportunity because he was holding the jacket where the gun was found right before Officer Ackard took the jacket. Opportunity because he was found with the exact same gun, a photo of the exact same gun on his phone, along with a photo of him possessing the exact same gun.
Okay, I think we have that argument. I'll thank you. Now, Mr. Sebald wanted earlier to be able to address this second issue, and we didn't give him the chance, so we're going to give him the chance now in response to your argument. Mr. Sebald, we'll ask you to keep it brief, though.
You're still muted.
You're on mute.
Oh, you're muted, yes.
Thank you, Your Honor. Thank you very much. As you realize, the court gave appellant numerous opportunities to supplement the foundation for this photograph. You have that argument. I'm not going to elaborate on it. After appellant tried to get in the second photograph at trial and asked the officer if it looked like the gun was the same, she then started looking at parts of the body-worn camera footage that she wanted to get in. And the court excluded them on hearsay grounds. That's what Ms. Ernest is referring to. It's at page 220 to 225 of the August 2 transcript. They were excluded on hearsay grounds, except for the statement where the officer says to the middle seat passenger, it's the same gun. But it's not really clear. It's not clear what he's talking about. He's just saying it's the same gun on the phone. And we know the first picture was the same gun. It had the same serial number. If she had thought that the body-worn camera was foundation for establishing that the second picture was relevant, that argument was never presented to the court. So this was a hearsay ruling that wasn't addressed in the briefs and wasn't proffered in any way relevant to admission of DX2. And so I just wanted to draw the distinction between the two, because the court wasn't asked to say, hey, there's this body-worn camera footage over here, and so for that reason, you should admit DX2. That would have been an ex parte proffer to the court, and then the court could have reviewed it and then made that decision. And so that was one other way, perhaps, and we don't really know what the officer would have said about some of those comments because he was never asked. We just know that wasn't proffered as foundation. And so for those reasons as well, we think that the court did not abuse its discretion. Thank you very much for the opportunity, Your Honor. I appreciate it.
Thank you. Counsel, thank you both. The case is now submitted.
Thank you.
The court will stand adjourned.
This court is now adjourned.